In this part 27, we will discuss chapter 10 of the Criminal Procedure Code, and the heading of the chapter is Maintenance of Public Order and Tranquility. As I have told you in the past, in order to know some of the provisions in detail as far as this chapter is concerned, the time for you to have reference to the second schedule of the Criminal Procedure Code, which deals with forms, and as and when it is necessary, you have to read from forms number 20 up to section 27 in order to understand this chapter in detail. Now this chapter is classified under different heads. First part of the chapter, right from section 129 up to 132 of the Criminal Procedure Code, this chapter, it deals with unlawful assembly, dispersal of assembly by use of civil force. The next part, right from section 133 up to 143, deals with public nuisances. Section 144 deals with urgent cases of nuisance and apprehended danger, and right from section 145 up to section 148 deals with disputes as to immovable properties. Now, in case of unlawful assemblies, there is a potential danger, and in order to have preventive measure, once you start dealing right from section 160, 129, power vests in the executive magistrate or officer in charge of a police station for the purpose of dispersal of such unlawful assemblies. And as we start learning this, we will understand any executive magistrate or officer in charge of a police station, or in the absence of such officer in charge of any police officer not below the rank of sub-inspector, may command any unlawful assembly or any assembly of 5 or more persons likely to cause a disturbance of public peace or to disperse, and it shall thereupon be the duty of the members of such assembly to disperse accordingly. Now, if upon being so commanded any such assembly does not disperse, or if without being so commanded it conducts itself in such a manner as to show a determination not to disperse, any executive magistrate or police officer as per subsection 1 may proceed to disperse such assembly by force, and may require the assistance of any male person not being an officer or member of the armed forces acting as such for the purpose of dispersing such assembly, and if necessary arresting and confining the person who from part of it in order to disperse such assembly, or that they may be punished according to law. Now, at the time of dispersing unlawful assembly, use of armed force is also used, and then if any such assembly cannot otherwise be dispersed, and if it is necessary for the public security that it should be dispersed, the executive magistrate of the highest rank who is present may cause it to be dispersed by the armed forces. Such magistrate may require any officer in command of any group of persons belonging to the armed forces to disperse the assembly with the help of the armed forces under his command, and to arrest and confine such persons forming part of it as the magistrate may direct, or as it may be necessary to arrest and confine in order to disperse the assembly, or to have them punished according to the law. Every such officer of the armed forces shall obey such a requisition in such manner as he thinks fit, but in doing so he shall use as little force and do as little injury to person and property as may be consistent with dispersing the assembly and arresting and detaining such persons. Now, this part of the chapter also deals with power of certain armed force officers to disperse assembly. And it says, when the public security is manifestly endangered by any such assembly, and no executive magistrate can be communicated with, any commissioned or gazetted officer of the armed forces may disperse such assembly with the help of the armed forces under his command, and may arrest and confine any persons forming part of it in order to disperse such assembly, or that may be punished according to law. But if while he is acting under this section it becomes practicable for him to communicate with an executive magistrate, he shall do so, and shall thenceforward obey the instructions of the magistrate as to whether he shall or shall not continue such action. Those who act during the course of dispersal of this assembly have protection as far as section 132 of this chapter is concerned. No prosecution against any person for any act purporting to be done under section 129 or section 130 or 1 section 31 shall be instituted in any criminal court except with the sanction of the central government where such person is an officer or member of the armed forces, with the sanction of the state government in any other case. No executive magistrate or police officer acting under any one of the state sections in good faith, no person doing any act in good faith in compliance with a requisition under section 129 or 130, no officer of the armed forces acting under section 131 in good faith, no member of the armed forces doing any act in obedience to any other order which he was bound to obey shall be deemed to have thereby committed an offense. So protection against prosecution for acts which are done and as per the above preceding section is dealt as far as section 132 of the chapter is concerned. So this is regarding dispersal of an unlawful assembly, who can disperse, how he can disperse, what is the procedure required to be followed is dealt as far as this particular part of the chapter is concerned. Now when we start right from section 133 up to section 143 of this chapter is concerned, which deals with public nuisances, and section 133 deals with conditional order for removal of nuisances. Whenever a district magistrate or subdivisional magistrate or any other executive magistrate specially empowered in this behalf by the state government, on receiving the report of a police officer or other information and on taking such evidence, if any, as he thinks fit, considers that any unlawful obstruction or nuisance should be removed from any public place or from any way, river or canal which is or may be lawfully used by the public, or that the conduct of any trade or occupation or the keeping of any goods or merchandise is injurious to the health or physical comfort of the community, and that in consequence such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed or the keeping thereof regulated, or that the construction of any building or the hospital of any substance as is like or the that the construction of any building or the disposal of any substance as is likely to occasion conflagration or explosion should be prevented or stopped, or that any building, tent or structure or any tree is in such a condition that it is likely to fall, thereby cause injury to persons living or carrying on any business in neighborhood or passing by, and that in consequence the removal, repair or support of such building, tent or structure or the removal or support of such tree is necessary, or that any tank, well, excavation adjacent to any such way or public place should be fenced in such a manner as to prevent danger arising to the public, or that any dangerous animal should be destroyed or confined or otherwise disposed of. Such magistrate may make a conditional order requiring the person causing such obstruction or nuisance, or carrying on such trade or occupation, or keeping any such goods or merchandise, or owning, possessing or controlling such building, tent, structure, substance, tank, well, excavation, or owning or possessing such animal or tree within a time to be fixed in the order, to remove such obstruction or nuisance, or to desist from carrying on, or to remove or regulate in such a manner as may be directed such trade or occupation, or to remove such goods or merchandise, or to regulate the keeping thereof in such a manner as may be directed, or to prevent or stop the construction of such building, or to alter the disposal of such substance, or to remove, repair or support such building, tent or structure, or to remove or support such trees, or fence such tank, well or excavation, or to destroy, confine or dispose such dangerous animal in the manner provided in the said order, or if he objects to do so, to appear before himself or some other executive magistrate subordinate to him at a time and place to be fixed by the order, and show cause in a manner hereinafter provided why the order should not be made absolute. No order duly made by magistrate under this section shall be called in question in any civil court. So these nuisances are enumerated, 6 categories are enumerated as far as section 132 is concerned, and then it makes mention as to what is the manner in which the order is required to be passed or can be passed by the authority. Now this order, once it has been passed, there must be service or notification of the order. The order shall, if practicable, be served on person against whom it is made in a manner herein provided for the service of summons. If such order cannot be so served, it shall be notified by proclamation published in such a manner as the state government may by rules direct, and copy thereof shall be stuck up at such a place or places as may be fittest for conveying the information to such a person. Now, the person to whom such order is, with respect to whom such order is passed, has to obey the order, or if not, then he has to show cause. The person against whom such order is made shall perform within the time and in the manner specified in the order the act directed thereby, or appear in accordance with such order and show cause against the same. Now, if such person fails to obey the order, the consequences are laid down by section 136. It says, if such person does not perform such act or appear and show cause, he shall be liable to the penalty prescribed in that behalf in section 188 of the Indian Penal Code, and the order shall be made absolute. Now, there may be a situation where existence of public right is denied, and what to do is made very clear as far as section 137 is concerned. It says, where an order is made under section 133 for the purpose of preventing obstruction, nuisance or danger to the public in the use of any way, river, canal or place, the magistrate shall, on the appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in respect of the way, river, canal or place, and if he does so, the magistrate shall, before proceeding under section 138, inquire into the matter. If in such inquiry the magistrate finds that there is any reliable evidence in support of such denial, he shall stay the proceedings until the matter of the existence of right has been decided by the competent court, and if he finds that there is no such evidence, he shall proceed as laid down in section 138. A person who has, on being questioned by the magistrate under subsection 1, failed to deny the existence of any public right of the nature therein referred to, or who having made such denial has failed to adduce reliable evidence in support thereof, shall not in subsequent proceedings be permitted to make any such denial. Now, when such a person appears to show cause, what is the procedure is laid down as far as section 138 is concerned. It says, if the person against whom an order under section 133 is made appears and shows cause against the order, the magistrate shall take such evidence as in the manner as in a summons case. If the magistrate is satisfied that the order, either as originally made or subject to certain modification as he considers necessary, is reasonable and proper, the order shall be made absolute without modification, or as the case may be with such modification. If the magistrate is not so satisfied, no further proceeding shall be taken in the case. Now, magistrate, for the purpose of satisfying himself, magistrate has got power to direct local investigation, and that is made very clear by section 139, which says, the magistrate may, for the purpose of an inquiry under section 137 or 138, direct a local investigation to be made by such person as he thinks fit, or summon and examine an expert. Magistrate has also got power to furnish written instructions as far as section 140 is concerned, which says, where the magistrate directs a local investigation by any person under section 139, the magistrate may furnish such person with such a written instruction as may seem necessary for his guidance, declare by whom the whole or any part of the necessary expenses of the local investigation shall be paid. The report of such person may be read as evidence in the case. So, and then during the time the inquiry is pending, magistrate has also got power to issue injunction as far as section 142 is concerned. It says, if a magistrate making an order under section 133 considers that immediate measures should be taken to prevent imminent danger or injury of a serious kind to the public, he may issue such an injunction to the person against whom the order was made as is required to obviate or prevent such danger or injury pending the determination of the matter. In default of such person forthwith obeying such injunction, the magistrate may himself use or cause to be used such means as he thinks fit to obviate such danger or to prevent such injury. No suit shall lie in respect of anything done in good faith by a magistrate under this section. Magistrate may prohibit repetition or continuance of public nuisance as per section 143, which says a district magistrate or subdivisional magistrate or any other executive magistrate empowered by the state government or the district magistrate in this behalf may order any person not to repeat or continue a public nuisance as defined in the Indian Penal Code or any special or local law. So this is regarding nuisance as dealt right from section 133 up to section 143 of the Criminal Procedure Code. Now, section 144 deals with urgent cases of nuisance or apprehended danger, and it says, in cases where, in the opinion of a district magistrate or subdivisional magistrate or any other executive magistrate specially empowered by the state government in this behalf, there is sufficient ground for proceeding under this section, and immediate prevention or speedy remedy is desirable, and the magistrate may, by a written order stating the material facts of the case and served in the manner provided by section 134, direct any person to abstain from a certain act or to take certain order with respect to certain property in his possession or under his management, if such magistrate considers that such direction is likely to prevent or tends to prevent obstruction, annoyance, or injury to any person lawfully employed, or danger to human life, health or safety, or disturbance of the public tranquility, or riot or an affray. An order under this section may, in cases of emergency or in cases where the circumstances do not admit of serving in due time of the notice upon the person against whom the order is directed, be passed ex parte. An order under this section may be directed to a particular individual or to persons residing in particular place or area, or to public generally, and when frequenting or visiting a particular place or area. No order under this section shall remain in force for more than 2 months from the making thereof, provided that if the state government considers it necessary so to do for preventing danger to human life, health or safety, or for preventing a riot or any affray, it may, by notification direct, that an order made by a magistrate under this section shall remain in force for such further period not exceeding 6 months from the date on which the order made by the magistrate would have, but for such order expired as it may specify in the said notification. Any magistrate may, either on his motion or on the application of any person aggrieved, rescind or alter any order made under this section by himself or by any magistrate subordinate to him by his predecessor in office. The state government may either on its own motion or on the application of any person aggrieved rescind or alter any order made by it under proviso to subsection 4, where an application under subsection 5 or subsection 6 is received, the magistrate or the state government, as the case may be, shall afford to applicant an early opportunity of appearing before him, either in person or by pleader, and showing cause against the order, and if the magistrate or the state government, as the case may be, he rejects the application wholly or in part, he or it shall record in writing the reasons for doing so. So this is with respect to the urgent cases of nuisance or apprehended danger as far as section 144 is concerned. With this, the last part as far as this chapter is concerned, which deals with disputes as to immovable property, and what is the procedure, how the breach of peace can be prevented, maintenance of peace can be done by the court of law, or what are the steps that can be taken by the court of law, because this is likely to lead to breach of peace, is made very clear right from section 145 up to section 148. Whenever an executive magistrate is satisfied from a report of a police officer or upon other information that a dispute is likely to cause a breach of the peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statement of their respective claims as respects the facts of actual possession of the subject of dispute. For the purposes of this section, the expression land or water includes buildings, markets, fisheries, crops, or other produce of land, and the rents or profits of any such property. A copy of the order shall be served in the manner provided by this code for the service of summons upon such person or persons as the magistrate may direct, and at least one copy shall be published by affixing to some conspicuous place at or near the subject of dispute. The magistrate shall then, without reference to the merits or the claims of any one of the parties to a right to possess the subject of dispute, pursue the statement so put in. Here the parties receive all such evidence as may be produced by them, take such further evidence, if any, as he thinks necessary, and if possible, decide whether any of which of the parties was, at the date of the order made by him under subsection 1, in possession of the subject of dispute, provided that if it appears to the magistrate that any party has been forcibly and wrongfully dispossessed within 2 months next before the date on which the report of the police officer or the other information was received by the magistrate, or after the date and before the date is ordered under subsection 1, he may treat the party so dispossessed as if the party had been in possession on the date of his order under subsection 1. Nothing in this section shall preclude any party so required to attend or any other person interested from showing, and no such dispute as aforesaid exists or has existed, and in such a case the magistrate shall cancel his said order, and all further proceedings thereon shall be stayed, but subject to such cancellation, the order of the magistrate under subsection 1 shall be final. If the magistrate decides that one of the parties was or should under the proviso to subsection 4 be treated as being in possession of the said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbances of such possession until such eviction, and when he proceeds under the proviso to subsection 4 may restore to possession the party forcibly and wrongfully dispossessed. The order made under this subsection shall be served and published in the manner laid down in subsection 3. When any party to any such proceeding dies, the magistrate may cause the legal representative of the deceased party to be made a party to the proceedings, and shall thereupon continue the inquiry. And if any question arises as to who the legal representative of the deceased party for the purpose of such proceeding is, all persons claiming to be representative of the deceased party shall be made parties thereto. If the magistrate is of the opinion that any crop or other produce of the property, the subject of dispute in proceeding under this section pending before him, is subject to speedy and natural decay, he may make an order for the proper custody or sale of such property, and upon the completion of the inquiry shall make such order for the disposal of such property or the sale proceeds thereof as he thinks fit. The magistrate may, if he thinks fit at any stage of the proceeding under this section, on the application of either party, issue a summons to any witness, directing him to attain or to produce any document or thing. Nothing in this section shall be deemed to be in derogation of the powers of the magistrate to proceed under section 107 of the Criminal Procedure Code, with which we have already dealt. With this now, the section 146 next section deals with power of the magistrate has got power to attach subject of dispute and to appoint a receiver. It says, if the magistrate at any time after making the order under subsection 1 of section 145 considers the case to be one of emergency, and if he decides that none of the parties was in such possession as is referred to in section 145, or if he is unable to satisfy himself as to which of them was in such possession of the subject of the dispute, he may attach the subject of dispute until a competent court has determined the rights of the parties thereto with regard to the person entitled to the possession thereof, provided that such magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of the peace with regard to the subject of dispute. When the magistrate attaches the subject of dispute, he may, if no receiver in relation to such subject of dispute has been appointed by the civil court, make such arrangement as he considers proper for looking after the property, or if he thinks fit, appoint a receiver thereof, who shall have, subject to the control of the magistrate, all the powers of a receiver appointed under the Code of Civil Procedure, provided that in the event of a receiver being subsequently appointed in relation to the subject of the dispute by any civil court, the magistrate shall order the receiver appointed by him to hand over the possession of the subject of dispute to the receiver appointed by the civil court, and shall thereafter discharge the receiver appointed by him. May make such other incidental or consequential orders as may be just. Now there may be dispute concerning right of use of land or water, and this has been dealt as far as section 147 is concerned. It says, whenever an executive magistrate is satisfied from the report of the police officer or upon other information that a dispute likely to cause a breach of the peace exists, regarding any alleged right of user of any land or water within his local jurisdiction, whether such right be claimed as an easement or otherwise, he shall make an order in writing stating the ground of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statement of their respective claims. The magistrate shall then pursue the statement so put in, hear the parties, receive all such evidence as may be produced by them respectively, consider the effect of such evidence, take such further evidence, if any, as he thinks necessary, and if possible, decide whether such right exists, and the provisions of section 145 shall, so far as it may be, apply in case of such inquiry. If it appears to such magistrate that such right exists, he may make an order prohibiting any interference with the exercise of such right, including in a proper case an order for removal of any obstruction in the exercise of any such right, provided that no such right shall be made where the right is exercisable at all times of the year, unless such right has been exercised within 3 months next before the receipt under subsection 1 of the report of the police officer or other information leading to the institution of inquiry, or where the right is exercisable only at a particular season or on particular occasion, unless the right has been exercised during the last of such seasons or on the last of such occasions before such receipt. When in any proceedings commence under subsection 1 of section 145, the magistrate finds that the dispute is as regards an alleged right of user of land or water, he may, after recording his reasons, continue with the proceedings as if they had been commenced under subsection 1, and when in any proceedings commenced under subsection 1, the magistrate finds that the dispute should be dealt with under section 145, he may, after recording reasons, continue with proceedings as if they had commenced under subsection 1 of section 145. For this particular purpose, there can be a local inquiry too, and it is laid down by section 148, which says, whenever a local inquiry is necessary for the purposes of section 145, section 146, 147, district magistrate or sub-divisional magistrate may depute any magistrate subordinate to him to make such inquiry, and may furnish him with such written instructions as may seem necessary for his guidance, and may declare by whom the whole or any part of the necessary expenses of the inquiry shall be paid. The report of the person so deputed may be read as evidence in the case. When any costs have been incurred by any party to a proceeding under section 145, section 146 or section 147, the magistrate passing a decision may direct by whom such costs shall be paid, whether by such party or by any other party to the proceedings, and whether in whole or in part or proportion, and such cost may include any expenses incurred in respect of witnesses and of pleaders' fees which the court may consider reasonable. So this is regarding right from section 129 up to section 148, dealing with maintenance of public order and tranquility. With this now, we intend to start with right from section 154 onwards of the Criminal Procedure Code, where we shall be starting with Criminal Procedure Code in the real sense of the term.